And the call is now being recorded.
Hi, good afternoon, everyone. This is Laura Hoffman from the firm of Feldsman, Tucker, Leifer, Fidell, and I'm here today with Molly Evans of the same firm to talk to you about the HIPAA final Omnibus rule and whether you're ready for the compliance date of September 23rd, 2013. So we're going to talk about a variety of different aspects of the rule today, and then if we have time at the end, we will go over some questions from people on the call.
Conference record has joined the conference.
And we'll do our best to address all the questions during that time. So if we could just advance to the next slide, please.
Thanks so much.
Thanks. This is our standard disclaimer. We just want to let everybody know that the training that you're receiving today should not be considered legal advice. That would require a much more specific analysis of facts for each particular situation. So, and then please don't copy and reuse the slides elsewhere. Next slide, please. So this is Molly Evans' bio. She'll be talking to you in the second half of the presentation. She's a partner here at Feldsman Tucker, practicing in the areas of nonprofit law, corporate and business law, and healthcare law, focusing on regulatory, transactional, corporate compliance matters, and employment law as well. And she was formerly in-house counsel for a large multi-site nonprofit in Washington, D.C., responsible for most of their risk management issues. Next slide, please. And as I said, I'm Laura Hoffman. I am an associate here at the firm, working in most of the same areas as Molly, healthcare law, corporate compliance, and government grants. A lot of that work includes doing compliance program audits and risk assessments for community health centers, but also talking about patient privacy and other kinds of contracting and risk management activities. In addition, I serve as the interim associate compliance officer for a multi-site community health center here in the district. All right, next slide, please. So the goals of today's webinar, as I mentioned, are to summarize the impact of the new HIPAA final rule on your health center, and to identify changes that you might need to make, including to your business associate agreements, to various policies and procedures, different training you might need to provide to your staff, and also understanding the consequences of noncompliance with the new rule. Next slide, please. So as many of you know, earlier this year, in late January, the Department of Health and Human Services, HHS, issued the final rule for enforcing HIPAA procedures, which were made into statute a few years ago through the HITECH Act and the Genetic Information Non-Discrimination Act of 2008. So a lot of these rules that are found in the new final rule, and I'm going to use final rule and omnibus rule interchangeably to refer to these regulations that came out on January 25th. A lot of the aspects of the final rule were already in effect in statute, but the HHS had not issued regulations to enforce those rules. So anyway, so this final rule now incorporates all of those statutory provisions and clarifies to a certain degree what health centers and other healthcare entities need to do to be in compliance with those statutes. Next slide, please. So here's your timeline of the HIPAA rule implementation. As we said, the rule first came out in January of 2013. It gave health entities a few months to get familiar with the new rule because it was pretty long, so it gave everybody time to go through it and read it and see what issues might impact their centers. But then on top of that, you have about 5 months to 6 months, I guess, 6 months to get your policies and procedures and agreements updated and making sure that they are in compliance with this new final rule, because in September is when HHS will begin enforcing the new rule. So in between the date of the March 26th and September 23rd enforcement rule, the effective date and the enforcement date, HHS kind of is offering a grace period during that time. So you could use the new rule to determine how your health center privacy operations would work, or you could use the old rule still. But in any event, if there was ever a point where HHS went in and had to reevaluate what you did in a certain situation, they would pay attention to what standard you were using at that time. So something to be aware of, but obviously in a couple weeks, everyone will need to be on the same page with the new rules, regulations on September 23rd. Next slide, please. So this is a summary of all the changes that, well, many of the changes that were adopted by the final rule. These are the big areas that we want to focus on for this training, because they are what will require most of the work for health centers to get ready for the effective date or for the enforcement date. And the things you really want to think about in terms of modifying agreements and publications that go out to your patients, but also the new breach standard and notification standard that you'll need to keep in mind while evaluating your breach. So I'm going to go through each of these bullet points in more detail. This is the overview. I'm going to talk about the breach definition and notification, and then Molly will talk about changes to notice of privacy requirements, modifications to an individual's access to his or her own PHI, which is protected health information, and new requirements for business associate agreements, BAAs. Next slide, please, and then go ahead and advance again, please. Okay, so we are talking about breach at this point, and there are a few components to the changes that came from the final rule in regards to breach. As you probably are familiar with, under the old standard of HIPAA, the breach was defined as an access to, use of, or disclosure of PHI that violates HIPAA, and 3 as bolded because this is the focus of where things have changed. The old standard, there used to be required a significant risk that such access, use, or disclosure would cause financial, reputational, or other harm to the patient, and then that there were no exceptions that applied to the circumstance. So this old standard, HHS received a lot of complaints and comments about how subjective it was, because it was often difficult for health centers to determine what a significant risk was versus a non-significant risk, and also what kind of harm needed to be suffered by the patient. What harm is enough, basically, to call it a breach. So it was sort of a fuzzy rule, and you know, there were probably instances where people were notified unnecessarily that something amounting to a breach had occurred. Maybe there wasn't actually a breach, and then vice versa. And in a worse situation where people were not notified when they actually should have been because of the subjectivity of the standard. It was hard to make a decision. So that is opposed to the next slide, please, in contrast to the new standard, where we have many of the same kind of intro here, an acquisition, access, use, or disclosure of PHI that violates HIPAA. And then again, this bold part is what has changed. Unless the covered entity can demonstrate a low probability that the PHI has been compromised based on a risk assessment of at least the following factors. And then these 4 factors we will get into in more detail in just a few slides here, but you want to note here that it starts out with a presumption of breach, and I'll talk about that in just a second, but as opposed to the old standard where you had to do a risk analysis to determine whether there was a significant risk and whether harm was suffered and what kind of harm there would be, here this new standard creates a presumption of breach. So let's look at that in the next slide, please. So this first big change, as I talked about, is now when there's an impermissible use or disclosure of PHI, again, there is a presumption that a breach has occurred. In order to combat that presumption, you would conduct a risk assessment to try to determine whether there is a low probability that the PHI has been compromised. So again, this sort of sounds subjective in its approach because, as we'll talk about, there are these 4 factors that you want to look at to determine whether there's a low probability that the PHI has been compromised. But it's different from the old standard in that your starting place is different. In the old standard, you would do your risk analysis first and then look at, again, the harm and whether the harm was significant, et cetera. But now you start from a place of saying, okay, we have a breach on our hands at this point. After we look at these 4 factors, which we'll discuss, is there any way we can come out saying, well, there actually is probably just a low probability that that PHI went anywhere or was seen by anyone, but it does create a different starting place. And now, because you presume a breach, that results in presuming that you will need to contact individuals who were involved in the breach, which is called breach notification. So because you're starting from a place of breach presumption, you also start from a place of presuming that you will need to perform a breach notification for the individuals involved. And so again, unless you can demonstrate a low probability of compromise of PHI, you need to be prepared and have policies and procedures in place to act, fairly quickly on breach notification to individuals or to the media or to the secretary, depending on how many people are involved. Look at the next slide, please. So again, this is sort of a change in the original breach definition, which we've already touched on, the interim rule defining the breach, and that dark blue box up top talks about significant risk of financial, reputation, or other harm to the individual, and also focused on compromising the security or privacy of PHI. So again, kind of subjective, could go either way. But again, the final rule eliminates some of this subjectivity because you don't need to worry anymore really about what a significant risk is. It takes away some of those things that you might not know about the individual and whether it would impact them in a certain way or not. So now instead of looking at the individual that is involved and their PHI on an individual level, you want to just look at the PHI and not really the individual involved. So you focus on the PHI in determining whether or not, basically, bottom line, that PHI has gone anywhere inappropriate and been accessed inappropriately. Okay, so now let's move on to the next slide and take a look at the 4-factor risk assessment. This is part of now you have had an unauthorized use or disclosure of PHI. You're starting from a place of presuming that there's been a breach because of the new rule. And so now what you can do is work through these 4 factors to determine whether you feel that there's a low probability that that PHI has actually been compromised. Because again, if it hasn't been compromised, then you don't need to perform the breach notification. But if you can't use these factors and other analysis to show that there's been a low probability, then you presume it's a breach and you go forward with the notification. All right, so let's look at the first factor. Next slide, please. Factor number 1, you want to look at the nature and extent of the PHI involved in the breach. So consider things like how sensitive the information is. For example, a lot of times when information is lost or discarded improperly, there can be financial information involved. So it can be credit card numbers, social security numbers, other types of billing information, which could lead to not only fraud for the individual, but also on behalf of the health center, and whether or not someone could find that information and fraudulently bill things on the health center's behalf that didn't actually really happen. So that's just a particularly sensitive area that should always be involved in a risk assessment of PHI. More probably familiar is a risk of clinical information that could be disseminated improperly. So consider the types of clinical information that might be on the PHI. So for example, you may have lost something in the mail, but you know that it only contains a name, an address, and a patient ID of someone, right? So it's not great that that got out, but it might not have a ton of clinical information on there, such as someone's diagnosis, someone's treatment, and details about that. So consider the sensitivity of the information involved. You also want to look at whether there are identifiers, again, like names or addresses, in that PHI. And again, the context is important because, as I mentioned before, you could have just a name and address and a patient ID, and there's not a ton necessarily that someone can really do with that information. But say another page is in with that mailing that gives the patient ID with no name, but also then a diagnosis or treatment. So the individual parts of the mailing might not disclose all of the information, but the mailing as a whole could enable someone to kind of match all the pieces together and figure out someone's name, address, patient ID number, billing information, diagnosis, treatment, etc. So obviously something like that would be pretty hard to show that there's a low probability that the PHI has been compromised. Okay, so let's look at the second factor. The second factor is looking at the unauthorized person or entity who used the PHI or to whom the disclosure was made. So basically here you want to look at where the PHI went. Was it lost, again, lost in the mail and you never got the mailing back and no one knows where it went? Was it disposed of improperly? You thought it was supposed to be shredded, but it wasn't shredded, but it may have ended up in a public dumpster. Was the PHI sent from your health center to a specialist, and so it was sent to an other covered entity? In that sense, it's a little bit better for you because the PHI is disclosed to someone who also is obligated to adhere to privacy and security rules. So, you may be able to take certain steps that will help make sure that the PHI isn't used further. And again, similar to the first factor, and you'll note as we go along that a lot of these factors are sort of intertwined, and that's why they should be used comprehensively to conduct your risk assessment. One factor is not determinative. You really want to look at everything together, and that's why there's certain overlap. You want to think about whether the information that's disclosed could make re-identification more likely. So in contrast, for example, of all of information being released from the health center, say, again, you send out this packet with all kinds of PHI in there, that's one thing. But in contrast, even if that's not the situation, say you send a bunch of patient names and billing information to a specialist, but then the specialist has the names and the billing information and diagnosis also at their disposal. That accidental disclosure could help someone at the specialist's office to link up who the information that came from your health center actually belongs to. But again, then you can counter that with, well, at least the specialist is most likely a covered entity and will be obligated to adhere to privacy rules that are existing. But you just want to make sure that you think about where the PHI is going, who may have seen it, and what their responsibilities are to maintain the privacy of that information. Okay, so we'll look at the third factor now. The third factor is whether the PHI was actually acquired or viewed. So, if you know that PHI was disposed of and it was shredded and but it fell into someone's hands, they're not going to be able to view that PHI. Contrasting that with sending a fax of patient information to the wrong fax number, and someone at an office building not related to healthcare at all picks it up and reads someone's healthcare information. It went to someone who shouldn't have gotten it. It was most likely acquired and viewed. And so again, that is a much higher risk of compromised PHI. And a couple examples that HHS provided in the Federal Register notice in its preamble to the final rule are listed here for you. An example of a low probability of breach is in the case of a stolen laptop computer. I'm sure many of your health centers have come across this, where someone leaves the laptop out somewhere, or there's a burglary and someone comes in and takes the laptop, something like that, and you think, oh my gosh, we have all of this PHI on here. Could they have gotten in and viewed all this PHI, and who do we have to notify now? But if that laptop, if you do a forensic analysis when you get it back, hopefully you'll get it back, and you can do an analysis, then you might be able to show that no one went into the computer, no one accessed the protected files, and so that is a low probability of PHI compromise. And HHS says that in its own guidance there. In contrast, you talk about here an unauthorized recipient contacting, actually, as I said before with the example of the fax number. Say you get a call from your local grocery store who says, hey, we got this information from your health center in our fax, and we took a look and realized that this is not something that we should be getting, so we just wanted to let you know that we received this information, which is great because you know what happened to it and that you know where it went and that they've notified you that this happened. But at that point, the PHI has been compromised because someone who wasn't supposed to see it saw it and has viewed this PHI. So two differences there. All right, let's move to the fourth factor, please. So the final factor in this test is the extent to which the risk of PHI has been mitigated, PHI exposure. So covered entities are responsible for taking efforts to mitigate risks, and so are your business associates now, by the way. They are responsible for trying to mitigate any breaches on their end. So there are different ways you can try to do that. You can set up a confidentiality agreement, and that works particularly well when the PHI goes outside of your network, maybe to another healthcare provider. You can set up an agreement saying we both are bound by the HIPAA privacy laws and agree that, though PHI was disclosed, we will maintain the confidentiality required by the HIPAA. So that's one way to make sure that the the exposure has been mitigated. You also want to think about whether for example, in the fax grocery store scenario, can you get an assurance from the grocery store that they will shred the PHI? That's one step they can take to make sure that no one else in the grocery store starts to view the PHI, or they don't throw it out in their public disposal bins out back and then someone else comes along and finds it there. So making sure that you take the steps to ensure that the PHI has been destroyed once it's been viewed. And then you always want to think about, in general here, whether the PHI remained within your network, because sometimes, as I'm sure many of you know, there's exposure to PHI even within the health center that shouldn't occur. Someone looks at the wrong medical record or sees a chart that they shouldn't see, and it could be intentional or accidental. But if it's if that exposure happens through someone in your own health center, it's much easier to kind of control that risk. And you obviously will know that they're bound by HIPAA rules. So even though that certain aspects of the privacy rule may have been violated by that individual looking at PHI that they shouldn't have, you at least kind of know that you can contain it, and you should have policies and procedures in place to know how to deal with that, and also disciplinary standards in place so that employees of your health center know the potential of what could happen to them if they do it accidentally, but also in case it ever occurs again. You want them to know that that is not acceptable and that they could face disciplinary action because of that. Okay, so let's move to the next slide, and this kind of reviews the flow. Whoop, I think maybe we skipped one. Yeah, thank you. This kind of just goes over the flow of what would happen again from the very beginning of when you realize that some PHI has been improperly disclosed. So you discover this improper usage of PHI. Again, now the next step you want to presume at this point, oh my gosh, we have it on our hands. We're probably going to need to contact the individuals involved to make sure that they are aware of the situation. So you're presuming your breach. Before you notify everybody, you are allowed to take a little bit of time, a reasonable amount of time, to conduct a risk assessment, which can help you determine whether you think there's a low probability of the compromise of the PHI. So again, doesn't matter about the harm to the individual or you know, whether there's a significant risk or not. You're just looking at whether the PHI has gone out, not been destroyed, who saw it, all those factors that we just talked about. And that's your fourth step there, and your fifth step. So once you've conducted that risk analysis now, you can determine more fully whether you need to notify the individuals involved or media or secretary. And a note about this step is when you conduct your risk assessment, you want to make sure that you really fully document everything. So I would suggest starting from the very beginning, almost working through this flow chart and documenting each of these steps. And under each of the 4 factors, test components, determine what results you reached, but also what facts you used to come to your conclusion. So under the number 1 of the 4-factor test, you know, say what the nature and extent was, why you decided that it was or was not a low probability of compromise, because that will be your best defense at any point if HHS Office of Civil Rights comes in. They're the office that enforces this privacy, and you want to be able to show that you used your best efforts and your policies and procedures in place to come up with the best conclusion here. Because if you determine that there's a low probability and you didn't do your notifications, you want to have backup to show why you did that. And it's much harder to recreate that in the future than it is to just do it right then at that time and make sure that you're fully covered. And also, you know, use this as a training tool as well. If you discover that in each of your 4 steps that there's been a common theme about something you could have done better, you can use that information to inform your future training of your staff. Next slide, please. So notification, say, all right, we've determined there's a breach. Now who do we notify? You need to notify the relevant parties, so the individuals involved, without unreasonable delay. Or you can do it within 60 days from the date of discovery, which is when you knew or should have known about the breach. So again, that 60 days gives you a window to conduct that risk analysis if you need to, but if you know that there's a high probability that the PHI has been compromised, or then you want to do that notification right away. You don't want to sit on it and delay it, but it does give you a window in which you need to disclose, and you can make the compromise. Okay, next slide, thanks. So now when you contact an individual, HHS lays out all the things that you need to include in that notification. And you should really think each time you send one of these letters to make sure it's in plain language. You know, obviously we want patients to understand what they're reading and to be able to allay any concerns, because obviously when anyone hears that some of their private information may have been breached, it can be sort of scary and confusing. So making sure that things are in plain language and including all of the information that they may have questions about. So you want just a short description of what happened, including the date where the breach occurred. It doesn't need to go into a ton of detail, but you can say, you know, some of our information was not shredded but was disposed of with our regular trash, and leave it at that. You might want to say the types of, you do need to say the types of information that were involved in the breach. You can talk about steps the individuals can take to protect themselves against potential harm. So even though you're not evaluating the potential harm to an individual, you need to think about what harm they may deal with. So, for example, if there was financial information involved, then, you know, include in the letter the phone numbers for credit monitoring agencies and say that they can contact those numbers to ensure that they just keep an eye on things with their finances. You also should include the mitigating steps that you've taken. So again, you know, we have told the recipient of the PHI that they should destroy it, and we've received a written confirmation from them that they have destroyed it. That would be an example. And finally, you want to provide contact information so that the individuals can follow up with you if they have questions or concerns, which is a fairly common and understandable thing. Make it easy for them to find somebody that they can talk to about it who can kind of put their fears at ease, their minds at ease, and be able to explain the situation more fully. And just a note on this too is that with these new rules, the covered entity can delegate this notification duty to their business associate if the business associate is the one that suffered the breach. You really want to think about who is best equipped to deal with the patients. You know, certain business associates obviously are clinical and others are not. So when you're sending these letters out to individuals, think about, even though the business associate could be required, you could make them conduct the notification. Just think about what makes the most sense for the patients. Next up, please. Slide. This is unchanged really by the final rule, but just a reminder for you that if a breach involves more than 500 residents in one particular jurisdiction or state, then you need to notify the media. So, you know, if you're a Florida-based health center, then and you had 500 individuals throughout the state, because you're obviously none of you are in Florida. But by way of example, if the individuals are spread out throughout the state or the jurisdiction, you want to make sure that everybody is contacted. So there's a notification that goes to the media so that everyone can kind of see it and be aware of what happened. If the breach involved greater than 500 individuals, for example, for any centers who have health centers maybe in different states or just spanning different areas of the state, then you need to immediately report that to HHS. They consider those types of breach to be a big deal, so they want to know right away. And then if your breach involves fewer than 500 individuals, you can just actually keep a log of that kind of breach, and there's a website HHS has a website where there's certain information you need to put in to describe that breach. And so again, documentation being key here, I would go into that website, print out the form that they make you fill out, and just use that as you go throughout the year to fill in all the relevant information at that time, so that you make sure you have all of it, because you'll be required to report that information on that website within 60 calendar days of the following year. So for all the breaches that have occurred in your health center for 2013 that involve fewer than 500 people, you should be documenting that, taking notes on what happened, and you will need to report that to HHS, each instance to HHS by like the end of February of 2014. Okay, next slide. So a couple of notification exceptions occur, which we've already discussed a bit, but if you have unintentional access by a workforce member that occurred in good faith and within the scope of their employment, so if someone accidentally pulled up the wrong chart, they were looking at Bob Jones Sr. instead of Bob Jones Jr., that's an exception. You don't need to worry about that. If you have an inadvertent disclosure between two of the covered entities' workforce, same kind of thing. You know, the nurse was talking to the doctor about Bob Jones Sr. when she actually was supposed to be talking about Bob Jones Jr. Same thing. Both entities there are covered by the privacy rules, and HHS says that's an exception. You don't need to report that. And then the third exception is, and we'll talk about this just in a minute, is that if a disclosure to an unauthorized person was deemed unable to have retained the information. So in that case, there's an exception, and I'll get more into that into the next slide. But that's a great exception to have. And I will explain why. But before I do, just a note on the bottom showing that the old rule contained an exception for limited data sets that didn't contain birth dates and zip codes. So if you had let out some limited data sets with those identifiers in there, HHS used to consider that an exception, but that is not the case anymore. So just something to be aware of. Okay, now the next slide, please, talks about this breach safe harbor, which relates to the idea that there's an exception if the PHI has been used or accessed by someone who can't have really attained it or accessed it or been able to really use it. So in that case, really the two words here you want to know are encryption and security. So making sure that all of your ePHI is encrypted will serve you very, very well in the future. It's actually a requirement of the security rule that electronic PHI is maintained in a secure way, and HHS doesn't tell you how exactly to do it. But for example, a lot of you probably heard about the recent case where HHS settled with a covered entity whose copy machine had retained PHI on it. So this should be a great time for you to look at how your electronic PHI is destroyed, because when they disposed of this copy machine information, they didn't properly destroy the information that was residing on that copy machine. So you want to make sure paper records are shredded or burned or pulverized so that no one can read it. You want to think about disposing of prescription bottles that contain PHI in opaque bags instead of clear bags, and you want to do it in a secure area or with a vendor as opposed to just chucking them in your dumpster out back. And then the same thing again with electronic media, making sure that the information is encrypted, secured, and then when you dispose of it, that your copy machines, your computers, if you rent any of those, are fully purged before you return them to the vendor that from which you received the machinery. Okay, next slide, please, and this just gives you sort of the bottom line review of what we've talked about. An impermissible use or disclosure of unsecure PHI is presumed a breach, because if your information is secure, it is not considered a breach. This breach presumption can be overcome by your risk analysis showing that there was a low probability of PHI compromise. So make sure you become familiar with those 4 factors and fully document it. And, you know, that being said, at the same time, you can always do the notification in the absence of the risk assessment. So as I mentioned, if you're sure that that the PHI has been compromised in a significant way, then you can just go ahead and move forward with the notification without doing the risk assessment. But you still want to document why you did that and the steps you took involved with that notification. And then finally, remember to secure and encrypt your data, because that can really be a saving grace at certain points if you know information got out, but it's secure and encrypted, so you don't need to worry about it. So Molly will take over at this point and start talking about notice of privacy practices and business associates.
Thank you, Laura. And thanks, everyone, for being on the call today. As Laura said, I'm going to take over the two other most important pieces of the new HIPAA Omnibus rule that health centers should be paying attention to, in addition to what Laura talked about with respect to making sure that you have a process in place in the event of a breach that matches what HHS hopes to see from you, and also provide you with sufficient documentation in case you have someone come in to audit how you've handled a breach, making sure that you've gone through the appropriate analysis on whether or not you're going to report a breach out or determine that something wasn't a reportable breach. So the other two important pieces we're going to talk about today are the notice of privacy practices, which should come as no surprise to any of you because you've been operating with a notice of privacy practices for some time at this point, and then business associate agreements. If we could advance to the next slide, please. Just in terms of a baseline in terms of what your notice of privacy practice should contain, three basic premises: a description of the kinds of uses and disclosures of PHI that you're going to have. So basically a description of what the health center is going to use patient health information for at the health center in terms of how it runs its business operations. What you as the health center, and when I refer to covered entity in these slides, I'm referring to you as the health centers, unless I say otherwise. So what you as the covered entity health center have as your legal responsibilities related to your patients' PHI, their health information, and three, the individual's rights related to their PHI, their rights to access, to amend, and otherwise their rights to privacy related to the protected health information that you possess on them as the health center. Importantly, the final HIPAA Omnibus rule makes some material changes about the kinds of things that must be a part of the notice of privacy practices. So if that's news to you, you have 2 weeks from today to pull out that notice of privacy practices and make sure that it has everything that the Omnibus rule requires in terms of what you reference to your patients in your notice of privacy practices, and make those changes accordingly before the compliance date. Now, just a note in terms of how health center boards work, obviously most of you, I'd venture to say 99% of you are your board's meeting on a monthly basis. So, you need to take into consideration if you're going to be changing the notice of privacy practices, and that's something that your board would otherwise approve, that you either have your executive committee make the approval before the 23rd, or have the board meet before the 23rd, or otherwise, to the extent that that is a board responsibility that your board has, either under your bylaws or under your HIPAA policies and procedures. So let's just talk about the types of changes that are in the notices of privacy practice. So can we go to the next slide? The change number 1, notices of privacy practices must contain statements indicating that the following PHI uses require authorizations: uses and disclosures of psychotherapy notes, uses and disclosures of PHI for marketing purposes, and disclosures that constitute the sale of PHI. These are important changes that your NPP must reference these three things now, to the extent that it didn't before. It should have statements about these three things. As you are probably aware, psychotherapy notes operate differently than the rest of PHI and cannot be produced as part of PHI unless there are particular requirements met. And the changes in the Omnibus rule really just reflect that you're giving notice to your patients that their psychotherapy notes have additional protections to them that they may not have otherwise been aware of. And remember, psychotherapy notes mean notes taken during a therapy session, the thoughts and observations of a therapist, not necessarily a medication prescribed by a primary care doctor or otherwise. It really relates to therapy going on in the health center, and that's the limited universe of psychotherapy notes. There is a definition, a clear definition in the HIPAA rule about psychotherapy notes. If that's a question for you, go back to reference that definition of what psychotherapy notes is, and we'll talk about what I see as a concern about psychotherapy notes and another issue related to EMRs a little later in the presentation, but just to make an asterisk by that maybe. But basically for these three uses, you need a statement in your Notice of Privacy Practices about what you're going to be doing in these three areas. Also, your Notice of Privacy Practice must indicate that any uses or disclosures that you do not mention in the Notice of Privacy Practices will require their individual's authorization. In other words, you don't have to include the entire universe of the things that you might use their PHI for. In the Notice of Privacy Practices, it would be a 100-page document otherwise, but you should have a statement in there that says that to the extent you're going to use it for something not mentioned in the Notice of Privacy Practices, you're going to get their authorization to use it for that. And that, of course, is not including the exceptions to the HIPAA privacy rule using the information for treatment, payment, or healthcare operations. So if we can go to the next slide. Did we skip one? Oh, I'm sorry, here we are. Just a note back, I'm sorry, can we go back to change number 1 just quickly? The last slide, thank you. Just a note about health plans. I'm assuming we only have health centers on the call, but just an FYI. For health plans, there is also a requirement in their Notice of Privacy Practices that they include a statement that they will not use genetic information on any patient for the purposes of any sort of underwriting that goes on. And that's from what Laura referred to at the beginning of the presentation, from the Genetic Information Non-Discrimination Act, or it's called GINA otherwise. You might have otherwise heard to it referred to as GINA, and you may have heard of it in an employment law context. But nevertheless, that particular change, which you may otherwise hear about, is limited to health plans and does not relate to healthcare providers themselves. Okay, thank you. Let's go to the next slide now. Change number 2, fundraising and opt-out clauses. Covered entities may contact individuals to raise funds in accordance with the HIPAA Omnibus rule, and we have a site here, 45 CFR 164 514 F1. If you're going to do that, if you are going to plan to solicit patients for fundraising purposes, you need to have an opt-out clause in your Notice of Privacy Practices that allows your patients to opt out of fundraising solicitations and gives them a way in which to do so. And the rule is clear that way should be not burdensome or costly to the patients, that you're not creating a multi-hurdle obstacle course that the patient has to go to opt out, that you have an easy and clear way to opt out of fundraising solicitations. And in this way, the Notice of Privacy Practices changes were both more permissive and more restrictive. And by that I mean you are now allowed to use PHI to solicit patients for fundraising opportunities. So in that way, it's more permissive, allowing you to do more with the information. However, more restrictive, you are absolutely forbidden to use that information once a person is opted out. And that's something to be aware of. And just as and I don't know for health centers how much you're using your patient information for fundraising efforts, but to the extent that you are, that is something to pay closer attention to. Also, if you're using it for marketing purposes, if you're using patient information for marketing purposes, not only do you want to reference that in your notice of privacy practices as we discussed in the last slide, also important to know that you take a closer look at the particular rules around marketing to make sure you're aligning with those appropriately, because there are certain restrictions that apply in terms of how you market to your patients. So just to make a note of that, if that's a practice that your health center engages in, make sure that you are aware of the HIPAA rules on that. We don't have time to really get into the nitty-gritty of those marketing rules, but something to be aware of. Okay, next slide. A third change to the individual's right to restrict certain PHI disclosures. The final rule requires covered entities to honor an individual's request to restrict PHI uses and disclosures when, number one, the disclosure is for payment or healthcare operations and is not required by law, and number two, the PHI pertains to an item or service paid in full by the individual or representative out of pocket. Okay. Now, what does that mean? That means that if your patient pays for a particular service, a particular visit, out of pocket, says, do not let my health insurer know that I'm here for whatever service it is, be it if it's mental health services or drug testing or whatever the case may be, whatever your patient doesn't want their health insurer to know and they're willing to pay out of pocket, they are allowed to restrict your ability to provide that information to the health insurer. In other words, I come in and say I need counseling, but I don't want you to tell Aetna. You have to keep those notes separate if I'm paying out of pocket for that service, so that Aetna never sees that I came to see you for my mental health counseling. Now, there are certain limited exceptions to that, including to the extent that it's for treatment purposes, that ability to exclude the information does not apply, and or in the rare event it's otherwise required by law, that would be an exception to this ability for the individual to permit or to request that you restrict the information. But other than that, individuals are permitted to ask you to restrict the information. That is a change from the previous rule. Your individual patients were allowed to ask you to restrict the information before the passage of this omnibus rule, but you as a health center or as a healthcare provider were allowed to say, that's fine, you can ask us to restrict it, but we don't have to see you if you're going to make that restriction. That is no longer the case. This is an additional protection for patients that came out of the omnibus rule. And for me, my observation and concern is the workflow change that will occur because of this rule. For those of you who have EHRs, which I'm sure is most of you, how you segregate information in the chart in the EHR, even in a paper chart, that is not part of the record that would go to a health insurer is complicated. How people down the line know that that information is segregated is complicated, and this is going to be a challenge for all healthcare providers and all health centers if this restriction comes up and someone pays out of pocket. So I think that is something, and because this is sort of a new frontier for everyone, there's no best practices out there that we've seen so far on how to make sure that you're doing this properly. But that's something to be aware of, focusing in on how your workflow is going to change around this to the extent you have a patient that asks you to restrict the information, how that is indicated in your EMR, and how you make sure that you don't send the information going forward. My previous comment about psychotherapy notes, I have a similar concern in terms of the EHRs that I've seen working with clients and ability to segregate psychotherapy notes from the rest of the records so that they're not released when there's a records request is another struggle that I see health centers having and something to be aware of. So both of these things are provisions that on principle and in theory sound good and offer additional protections to patients, but in reality and in day-to-day operations become really difficult to operationalize. In terms of what you must say in your Notice of Privacy Practices, that the Notice of Privacy Practices itself needs to contain a statement that notifies your patients about their right to restrict disclosures in the manner I've described above. Next slide, please. Notice of Privacy Practice change number 4, the right of affected individuals to be notified in the event of an improper PHI disclosure. Again, this is new, that the Notice of Privacy Practices must now indicate that an individual has the right to receive notification in the event of a breach affecting his or her privacy, and that the covered entity's requirements to communicate the news of the breach to the affected individual are also included in the Notice of Privacy Practices. These can be brief statements. They don't have to have your entire detailed process of what you do in the event of a breach, but the NPP itself must have statements about how you're going to notify a patient if there has been a breach. In addition, although not a change, your NPP also should have information about how who your patient contacts in the event that they're concerned about a breach of their privacy or security based on their protected health information. Also something that should be in the NPP. Next slide. Methods for implementation. So now that you're going to make all of these changes to the Notice of Privacy Practices, what do you have to do to let your patients know? Providers with a direct treatment relationship with their patients must, and I'm assuming that that means all of you as health centers, you're all providers with direct treatment relationships. Number 1, make the Notice of Privacy Practices, this is the amended Notice of Privacy Practices, available upon request beginning on September 23rd, 2013, so 2 weeks from today. Comply with the rule about having the Notice of Privacy Practices available at your delivery sites, so at all of your sites where you're seeing patients, that you have it posted in a clear and prominent location so patients are familiar with it, and providing copies of it, of the new revised and amended Notice of Privacy Practices to your new patients, and making sure that you have copies available to your existing patients to the extent that they request it. Also importantly, if you have your Notice of Privacy Practices posted on your website, make sure that you also change it and update it there to ensure that you have the most up-to-date and compliant Notice of Privacy Practices on the website. So that's the patient's first point of contact with the health center, that they have the correct information. For documentation purposes, it's important that you, while you amend your Notice of Privacy Practices to have all of these new provisions in them to the extent that they didn't already have it, make sure that you retain the prior copies, the prior iterations of your Notice of Privacy Practices. Again, creating some documentation around your HIPAA program at your health center, and also acknowledgments of receipt by your patients, even though they may be acknowledging receipt of the old Notice of Privacy Practices. You're creating a documentation trail to show an auditor about how you've been complying with HIPAA, and throughout, through HIPAA's own iterations. And as a sort of a little bit of a non sequitur, but important to note, in working with a health center recently on a upcoming FTCA site visit, we received the document list from HRSA regarding the documents that HRSA wanted to see
in order to make sure that the person was compliant with FTCA requirements. And among those documents requested were HIPAA policies and procedures, which was surprising to me because that's not necessarily generally part of FTCA compliance. It's not part of the FTCA statute or regulations. I don't even think it's mentioned in the FTCA policy manual, but nevertheless, these HIPAA policies and procedures are not just things that the Office of Civil Rights of HHS, and that's the agency that regulates HIPAA compliance. They're not just, that's not the only agency that's going to be looking at your HIPAA policies and procedures and making sure that they're correct. HRSA itself on these FTCA site visits is now starting to ask for this information. So just another reason to make sure that you're compliant as if you didn't already have enough. Next slide, please. What does this mean for health centers? What do all of these changes related to the Notice of Privacy Practices mean for you, especially the ones related to this individual right to restrict information? Some questions that HHS anticipated in making this rule and covered in their in the publication of the rule. Is a new record-keeping system required? And that's what I was referring to related to how you segregate the information in your EHR. HHS says no, but says that providers must employ a method to, quote, red flag or, quote, make a notation in the record to prevent an inadvertent transmission. That sounds a lot easier than it actually is in operation in my experience. But nevertheless, HHS is telling us that, no, you don't need a new system to keep this information, but you need to somehow designate it as sort of off limits related to a health insurer or payer. What if the law requires disclosure of the information? Then HHS says, again, you must disclose, reiterating what is obvious. If it's required by law, then you are required to disclose it. And then in terms of what Medicare and Medicaid expectations are, again, HHS says here that if the disclosure is required by law without exception to submit the claim, then you must submit the claim. But if a Medicare beneficiary pays out of pocket, then you must restrict the information just like you would on any other private insurer. If we could advance to the next slide, please. What if, here's some more questions that HHS anticipates being a problem for people. What if the individual requests to unbundle services? In other words, the individual wants the insurer to pay for some of the services, but doesn't want them to know about the other services. Surprisingly, and I think really, this makes it really difficult on providers. HHS says, if possible, you are expected to comply with a patient's request to unbundle services so that they can have some services provided confidentially without notice to their health insurer. They do say that if the unbundling is not possible, then the healthcare provider should explain to the patient about the right to restrict PHI by either paying for the entire set of services out of pocket or going somewhere else if that's not going to work for the patient. And HHS also does clarify that you are not required to notify downstream providers. In other words, if you are going to send the person to a specialist or refer them out to someone else, you're not required to notify that provider of the restriction placed on the information, but that you are encouraged to assist patients in notifying the downstream providers. So, again, not a requirement, but an encouragement, which is always suspect in my mind when the government is encouraging you to do something. But nevertheless, that's what the rule is at this point. Next slide, please.
I'm doing one thing, not like this.
In terms of what happens if you're dealing with an HMO and you have an HMO contract that says
that you are not allowed to accept any payment from the patient above the cost-sharing amount. If you have a HMO contract that says that you can't accept payment, in other words, the HMO contract forbids you from getting payment from the patient out of pocket, then you are supposed to counsel the patient that's the case and offer to refer them out of the network so that they can restrict their PHI to their insurance company. Also clarifying, does the restriction apply to family members who make payment on behalf of an individual? Yes, the restriction goes, if a parent's paying for a child or otherwise, they can still request the restriction that we've been talking about in the past couple of slides. And then to make it even more complicated, I think, follow-up care. Again, pay close attention to this number 8. If the individual patient does not pay out of pocket for a follow-up service of a previously paid service, the provider may include restricted PHI from the first visit in the bill to the health plan to prove medical necessity or appropriateness as long as it's consistent with the minimum necessary policy. So translated into plain English, if your patient comes for visit, if your patient has restricted you from notifying insurer about visits 1, 2, and 3, but on visit 4 wants you to bill insurance, and you need to demonstrate the medical necessity of that visit by then showing what happened in visits 1, 2, and 3, you are permitted to do so as long as you are only providing them with the minimum necessary information to make that analysis. So that's a lot of legwork related to getting paid on that visit 4 because you're doing an analysis on what is the minimum necessary amount of information, or whether or not you even have to include any information from visits 1 through 3 to get paid for visit 4. It gets dicey and complicated to do so, and is a heads up to get prepared for this piece. It's unclear how many patients will ask to do this, and so how often you're going to be dealing with this on a regular basis. But to the extent you are, just know that for follow-up care, to the extent that you are going to be requested to submit something to insurance, you can then submit the prior information that was previously restricted. Next slide, please. Another important piece of information, the final rule gives individuals access to electronic PHI upon request. So this amends the previous rule and requires that if your patient requests an electronic copy of their medical record, that you must provide that in a form that is easily producible to the patient, and that you must provide it in a way that the patient can read it and access it in an appropriate way, and also make sure that you see this on the right side, the additional requirement that you provide machine readable copies when possible, meaning that when someone loads plugs a zip drive into their computer, that they can open it up and see it. Also note that requests for PHI to be sent to third parties must be written, signed, clearly designate a recipient, and include a destination location. The HHS has said in the Omnibus rule that you should be providing this information to your patients within 30 days of their request, but you can request a 30-day extension to the extent that one is required and otherwise reasonable for you to have that extra 30 days to get the information in a manner that allows you to provide the information to your patients in a readable way. Just quickly, a couple of other changes about access that were part of the Omnibus rule. I don't know how much impact they might have on you, but they're generally, even as you may be aware, previous to the Omnibus rule, if someone died, restrictions around their patient health information and their protected information stayed in place, regardless of the fact that they were deceased, and they, as if you didn't have a personal representative as defined by HIPAA designated by the person prior to their death, it became very difficult to provide information to anyone, and it involved sometimes going to court to be designated a personal representative, which was very arduous, especially for health center patient populations that have no resources to either have help them understand how to access this information or go to court to access it. There is a new exception for decedent's PHI if it's been, I don't see how helpful this is, but if it's been more than 50 years, that you can disclose that PHI to a patient's family member if the decedent had otherwise mentioned the family member prior to dying. But HHS makes clear to note that that is only relevant if the decedent said that was okay. If the decedent prior to dying said, please don't give it to my sister, brother, child, then that would not apply. The other important access piece that is changed in this new rule is that you are permitted to provide information about childhood immunizations with the oral agreement of the parent or a guardian or other person acting in locus parente, only with respect to childhood immunizations alone, not otherwise in terms of child health information. But that is another sort of loosening of the HIPAA rule around childhood immunizations, acknowledging that people need that information to start school and otherwise, daycare otherwise, and that the access is more important than the restrictions. So let's move on to business associate agreements and what you need to know about business associate agreements. And we'll go to the first slide in this section, which the most important takeaway, I think, related to business associate agreements is that there is an expanded definition of business associates. More people are now treated as business associates than were before, and you need to make sure that you have agreements in place with your business associates in order to make sure that you are appropriately protected as you transfer PHI to those persons. The other important thing to note, which I don't think is always clear, is that someone is a business associate by definition in the rule. You can't say they're not a business associate because we don't have a contract with them, or they can't say to you, we're not a business associate of yours because we don't have a contract with you, so we don't have to worry about these rules. The definition in the rule itself sort of makes the person or the company or the entity a business associate of you, the covered entity. They don't get to choose whether or not they're a business associate. And the other important piece to note is that you don't get away from this business associate rule and set of issues by saying we're just not going to do contracts. Contracts are required. As a covered entity, you are required to demonstrate that you have satisfactory assurances that the people you share protected health information with are going to treat it with the same kid gloves that you are, and you must have a contract. By the rule, you must have a contract as part of those satisfactory assurances. So to the extent you get pushback from any of your business associates about whether or not they're going to sign a contract with you or whether or not they actually are a business associate, you can refer them back to the rule and say that it's not a determination that you're making. They either are or are not a business associate as defined by the rule. Importantly, we talked about the compliance date and the enforcement date. Laura talked about it, and I did, September 23rd, 2013, 2 weeks from today. It's important to note that with respect to business associate agreements, if you have not renewed or modified your business associate agreement between March 26, 2013, which was the effective date of this HIPAA Omnibus rule, so last March, and September 23rd, 2013, So if you haven't changed the business associate agreement during that time, you have until 2014, March 23rd, 2014, a year and 2 weeks from now, to come into compliance with this part of the rule. Basically, it makes sense if you think about it. As of March 26, 2013, you were on notice that you had to have these changes to your business associate agreement. And so if you change your agreement after that date, you need to have the new requirements in them. But if you're still working out your agreement between now and a year from now, you have a little bit more flex time to come into compliance with this part of the rule. And that's just something to be aware of. The two things that you should be doing with respect to your business associate agreements are, number one, pulling them out and updating them to make sure that they have all of the required provisions in them. And number two, going through your list of vendors and other people that you affiliate with or work with and asking yourself whether those people are business associates or not, and making sure that you have contracts with them. Next slide, please.
These are all the things.
Basically, the business associates generally fall into the fields of legal, accounting, data aggregation, people that do data aggregation on behalf of the health center, administrative, financial, actuarial, consulting, management, and accreditation organizations. Added to that list that I just read out in this new Omnibus rule are patient safety organizations. And those are, for those of you who are not familiar, patient safety organizations are organizations that you provide QI data to that are, by federal law, that information is protected in sort of a peer-reviewed kind of protection and allows that information to be protected from discovery in a lawsuit. And these are, by statute, organizations that exist for that purpose, for patient safety purposes, quality improvement, and protect information in that way. So if you contract with a patient safety organization or otherwise work with one and provide patient information to that patient safety organization, then they are a business associate of yours. The other addition, health information organizations, these include people that you provide that provide data transmission services with respect to PHI to a covered entity and that require routine access to such PHI. And also, HHS clarified persons who offer personal health records to one or more individuals on behalf of a covered entity. If you're contracted with a company to provide a personal health record to your patients, that person is also considered a business associate of the health center. The sort of flip side of that being that organizations that are conduits of health information like FedEx, United States Postal Service, people like that are not business associates. They are not people that require routine access to your patient's PHI, and they're not otherwise business associates of the health center. It also does not include providers. That is a common misconception that if you're contracting with another provider, either through a referral agreement or other sort of affiliation agreement, that they are a business associate of yours. That's not true. They are also a covered entity, and they themselves are required to comply with HIPAA as a covered entity, just like you are. They're not a business associate of yours. Business associates are generally people that are doing functions of the health center's operations for them on their behalf, not people that are providing care like the health center, not healthcare providers. Also, government agencies to whom you provide health information for eligibility and enrollment are not business associates. And to the extent you're part of an organized healthcare arrangement in a larger entity, to the extent that you're working with other parts of the entity that are not like a university system or otherwise, you may not be, another part of the university may not be a business associate of yours.
So, Molly, this is Dwayne Taylor. Just a quick question. So many of our health centers are contracting services such as substance abuse counseling or therapy because they don't have a psychologist on board or whatever. Well,
yes.
So they have, by definition, have to have a contract with those entities to cover the services that underneath the 19 core that they have to do. So would you consider that as a covered entity? As obviously they're a covered entity for the purposes of HIPAA, but would
right.
you say that they need to have a business associates agreement with them embedded into their contract, or some language that talks about sharing of information that's protected, or how would you go? What kind of language would you think they needed to have to protect?
Thank you. That's a great question. So my advice would be that you would have language in the contract that says that everyone complies with HIPAA, and you would make sure it was clear that you were talking about all of HIPAA, HITAG, Omnibus rule, all of that. And you would have clear language about patient confidentiality and everyone's complying with HIPAA, but they are not a business associate of the health center. If you're referring out for healthcare services, that is not a business associate. And is that good news?
Great news. Thank you so much.
Good. Sure, I'm glad I could provide one bright light during this whole thing, which is otherwise a big headache for everybody, I know. Okay, let's go on to the next slide. Another new addition are subcontractors, and this, so I would say this part of the presentation, because you're probably mostly all covered entities, this is just something for you to be aware of, that other people are going to have the same headaches that you're having now. Subcontractors of a business associate are now also considered business associates. So if your business associate gives your patient's protected health information to someone that they contract with, you know, down the chain, that person also has a obligation as a business associate. And this is another big change for business associates, that they are now directly liable to HHS for any sort of breach of protected health information. Before, HHS could come after you, the covered entity, for a breach, but not the business associate. That was between you and the business associate. Now HHS can reach into the business associate itself or its subcontractor and enforce actions against the business associate for a breach of the HIPAA rule. So that's a big change that doesn't necessarily affect your day-to-day operations, but something that you should be aware of, and definitely something your business associates need to be aware of. Okay, next slide. Okay, so like the first bullet is what I've just said. Business associates are directly liable for their own violations. Business associates are required to report the breaches to the covered entity, to you, to the extent they have a breach. Your contract with them, your business associate agreement would say that they have to report the breach to you. They must limit the use, the business associate agreement itself limits the use of the information to the minimum necessary standards, meaning that they're only getting exactly what they need to do their jobs, and they're not getting any more information than that. Again, the minimum necessary standards have been around since the beginning of HIPAA, but they create an analysis question for people. Every time you provide information to someone, you're having to think through, are you giving them anything more than they need to do their job? And if you are, then you create additional liabilities around that. When the covered entity delegates privacy rule responsibilities to the business associate must comply to the same extent as the covered entity. And covered entities and business associates may contract with regard to issues outside the realm of HIPAA privacy and security rules. So, for example, that's an important point to note, that there are certain required provisions as part of the BAA, but that doesn't stop you from also adding additional protections as a health center that you give yourself when working with your business associates, like an indemnification provision, where you say, an indemnification provision meaning that you say,
if you mess up and someone sues us for your mess up, then you have to pay us for all of our legal fees, for any judgment against us, for any fines or fees against us. A clause like that protects you from any problems that your business associate may create on his own or her. Next slide, please.
That number right there, 1-800-645. Okay.
Okay.
I would like to tell everyone to please mute your phones, please. Thank you.
It's Dexter. That's the problem. Imaging support, but you call right here.
I'm not sure she knows that she's not muted.
800.
I can hear someone talking to someone else, and I would just like to tell them to mute their phones, please. Thank you so much.
Okay.
I think they just heard me. Thank you so much, Molly.
Okay, no problem. Okay, some sample. So HHS does not have a sample business associate agreement out there for people to use, which they should, but they don't. But they do have sample provisions that you can access by. We have the website link here. You can go onto the HHS website and look at the sample provisions, see if your business associate agreement has those provisions in it, and if not, consider adding those. Also consider these kinds of questions when looking at your business associate agreement. Who notifies individuals of the breach? Like Laura mentioned before, depending on who the business associate is, it may be better for you as the health center to notify the patients of the breach, even if the breach happened as part of the business associate's problem, because you have the relationship with your patients trust you. You might be able to convey the information in a way that doesn't get them more upset than they would otherwise be because they weren't even aware that you were sharing their information with the business associate. It might just be a better way to notify your patients. And that should be part of your business associate agreement, a delineation of who is going to notify your patients. Also, who pays for the notification. Obviously, if the business associate has created the breach, they should pay for that notification. And who pays for breach mitigation? Again, same thing, and that could be rolled into an indemnification provision that the business associate would be responsible for paying for any mitigation. If you had a large breach, mitigation might include a massive mailing to all of your patients plus credit report checks for the next year, every 6 months or otherwise, that you would want the business associate to pay for if the breach was at their hands. Covered entities, business associates, and subcontractors, we talked about this, may use the existing contracts for at most 1 year beyond the compliance date. So really you have this time to get your business associate agreement into good shape to be compliant with this omnibus rule. Next slide, please. Okay, what's going to happen if we don't do everything we're supposed to do? No. There are civil penalties that are available to HHS to the extent that there have been breaches of the HIPAA privacy, security, or omnibus rule. And there is a tiered system that analyzes how HHS is going to determine how much money they're going to ask you to pay. And it's based on how much you know about the violation. Did you have an intent to violate the rules, and did you have any effort to correct the violation? Basically, there's going to be no excuse for not knowing that it's not going to be acceptable to say, I didn't know the rule changed and that this was a problem. But to the extent that you can demonstrate knowledge that you had an operational HIPAA compliance program in place, that you can show that you were, reporting breaches as required, that you were doing these analysis that Laura was talking about as part of the breach notification, that you've documented steps you've taken to mitigate, like she talked about signing a confidentiality agreement or otherwise cutting off the bleeding that might have occurred if there's a breach notification. That's going to matter a lot in terms of how money damages you may be assessed. The penalty range is $100 to $50,000 per violation, and you'll see the maximum penalty in any given year is $1.5 million for violation of an identical provision. But remember, if you had 3,000 patients' information released, each release of a patient information, each individual patient is a violation. So you can see how that can add up quickly and why there's a cap of $1.5 million. If you had a disclosure of 3,000 patients at one time, that would count as an a violation of identical provision. And so just to be aware of the real consequences of HIPAA. And since I've been doing this, and I really started, I think I came out of law school at the same time that the original HIPAA privacy statute was in place in 2000, and there, for the past 13 years, there hasn't been a ton of enforcement on HHS's side. They haven't had the staff to really enforce, review, or otherwise audit how people are doing with HIPAA, and so it sounded a bit like the boy who cried wolf to say that you need to be concerned about it because there hasn't really been an enforcement. And that is changing, both with the amount of staff that the Office of Civil Rights has hired to do these audits and otherwise review this information, and also just the climate in terms of internet safety and privacy of information. People are more attuned to that than they were in sort of the beginning of the brave new world of the internet. So it is something that is on the horizon to be aware of, and to be clear that there could be a HIPAA OCR audit coming your way, and so better to be aware and get your programs into place now before the compliance dates, so that you can demonstrate that you've been making every effort to remain in compliance. The other thing that I'll just quickly note is that in my experience, the more people that are aware of HIPAA in the health centers, both on the board and patients and providers and frontline staff, patient registration clerks, otherwise, the more you train people up, the more you're going to find out about problems in the health center. And I think that's a good thing, that people are becoming more knowledgeable about what would be considered a breach, and you're getting these things in place to take care of them. But especially in talking to your boards, it's important for them to note that an uptick or a sort of resurgence of these claims, if you're finding that you have more and more breaches going on at the health center, I think that relates to education more than the fact that there are more breaches around. I just think that people are becoming more aware, and there'll probably be an uptick for all of us before we can get these things in place to handle them. And also, as people figure out how to use their EHRs in safe and secure ways, there's a learning curve attached to that we all have to be aware of. And so last slide, just in conclusion about the BAAs and the final rule itself, there are robust changes to HIPAA from before and HIPAA as of September 23rd. And so as you walk away from this webinar and appropriately panic, these are the things that I would think that you should consider revising and entering into BAAs, really going through an analysis of who is a business associate of the health center and making sure that you have a business associate agreement with that person, modifying your privacy policies, including your notice of privacy practices and your other privacy policies, to making sure that they are compliant with the Omnibus rule, training and educating your staff on the changes, just like everything else in the health center. If your staff isn't aware of how things work and the compliance rules, then it doesn't matter what you have in place. It really needs to be operationalized, and everyone that touches PHI needs to be aware of their responsibilities around it. And finally, creating an action plan in the event of you have an inadvertent noncompliance with the final rule. How are you going to handle that? What's the analysis you're going to go through, and the step-by-step process that the health center goes through to make sure that they handle a breach appropriately. And just remembering that compliance date is September 23rd, 2013. And I think that is our last slide. We've gone over a little bit, and we are happy to take some questions now. But if, in the interest of time, if people have to run to their next meeting or otherwise, you also have our email addresses here, and we'd be happy to answer some questions on email as well, to the extent that you can't stick around for some questions.
Thank you so much, Molly, and thank you so much, Laura, for presenting. I understand that we're over 3, but we do have a few of you still on the call, so if you have any questions, please feel free to ask now. Or you can email them to Molly and Laura. So with this, I would like to conclude today's webinar. If anyone has questions, again, you can email them to Molly or Laura, or you can email them to me if you would like, but I would prefer that you email Laura or Molly. And if anyone has any other suggestions, please email them to me at aneeqa@mac.com. Again, thank you so much, Molly and Laura, and I hope you all have a lovely day. Thank you.
Thank you. Thank you.